presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes, the Court of Appeals is now in session. God save the state and this honorable court. Be seated.
Good morning, everyone, and welcome to the Court of Appeals. The matter we have on before us today is Simmons. This matter is back on the calendar for rehearing. I'm Judge April Wood, and to my right is Judge Jefferson Griffin. To my left is Judge Julie Flood. We also are joined today by our courtroom clerk, Mr. Roger McFarland, and our marshal, Mr. Richard Romiard. And at this point, I believe we have before us Mr. Archer for the appellants, and Mr. Hutchins for the appellees. Yes, ma'am. Are there any preliminary matters at this point?
None from the appellant, Your Honor, other than we want to reserve 7 minutes for rebuttal.
Thank you. We'll reserve 7 minutes. Thank you so very much. All right, then we will go ahead and hear from the appellants.
Good morning, judges. May it please the court. My name is Chad Archer. I represent the appellants in this matter, the Simmonses, and I also have my colleague, Henry Hilston, who also represents the appellants and who will be arguing in rebuttal. This matter is on for rehearing, and we believe that the court decided this correctly the first time around. There are essentially 3 areas that we want to discuss this morning. The first of those is what we contend is a failure to preserve the issue for rehearing. The second of which is some cases that we believe counsel in favor of reaffirming what the court previously found, including cases from this court and the Supreme Court. And the third area to be addressed is some statutory schemes that we believe are applicable and again suggest that the court's original decision should be upheld. On the first issue of preservation, we've noted in our brief that when this matter came on for hearing, as far as we know, in the clerk's jurisdiction, there was a de novo review of that in Superior Court. It's not transcribed, but certainly on the transcript in Superior Court in Yadkin County, there was no arguments that are like the arguments being advanced in the appellee's brief on rehearing advanced at that time. The only arguments that were made there were really to challenge whether the Rule 60 motion should be made on the merits. And a lot of that, if you read through the transcript, and I think it's pages 6 through 8 of the transcript, deal with scapegoating of the appellants to some extent for delays in having the hearing held and why they thought there was just no basis for setting aside. There was never any mention of Rule 60 isn't allowed in a non-judicial foreclosure. There was never any discussion of the Supreme Court's decision in Lux. And under Rule 10, we think that the failure to raise those types of arguments at that time was a waiver of the arguments that are now being advanced on rehearing. That's one element of the failure to preserve the alleged error. The other element of which is a failure of appellate preservation. And that's when this matter first came on for hearing in front of this court. The appellees, and it was their right to do so, elected not to file an appellee brief. Well, if an issue isn't presented in an appellee brief, on the initial hearing, the rules and the case law suggest that you cannot raise that as a basis for rehearing. You had an opportunity to bring it to the court's attention, and you didn't use that authority. And now that we have one opinion from this court, there's a presumption of correctness that attaches to it, and having so attached, you can't raise that untimely argument at this point. So we think those are all issues that say why maybe this shouldn't have been granted in the first place, but even if it is having now been granted, the court should conclude that those errors are not preserved and are not a basis for setting aside the original opinion. On the second point, there is, again, the primary thrust of the arguments on rehearing appears to be that under the Supreme Court's decision in Ray Lux, that only rules of civil procedure that are specifically engrafted into Chapter 45 are applicable. Rule 60 is not cited in the statutory scheme set forth in in Chapter 45. So ipso facto, you can't have a Rule 60 motion be brought in a non-judicial foreclosure under Chapter 45. What we contend the problem with that argument is the Supreme Court of North Carolina has explicitly sanctioned, it seems to us, the use of Rule 60 in a non-judicial foreclosure. And the case that we cite for that is the N. Ray George decision.
So in George and I think it's ACA, was there any distinction? I mean, what was the relief sought in those two cases for the Rule 60 motion?
I believe in both of those cases, certainly in George, it was essentially a voidness argument. So in George, it was an HOA foreclosure, but under the HOA statute, that statute says you can foreclose on an HOA lien under the Chapter 45 scheme, and it was void for lack of personal jurisdiction. I think if I read the court's first opinion in this case, it was void for lack of subject matter jurisdiction. Both personal jurisdiction and subject matter jurisdiction are challenged under 60B4. And Rule 60 also has subdivision C, which is specifically applicable to matters that are heard before the clerk. And so in George, the borrower, for lack of a better word, I guess the homeowner in that case, brought the motion under Rule 60. It was heard initially by the Supreme Court on that personal jurisdiction failure issue. They succeeded in granting it in the trial court. The HOA appealed. This court, in a divided opinion, affirmed and said it was correct to grant the Rule 60 motion. And this is after Lux has already been decided, is the critical thing to remember there. And there was a split decision. It gets appealed to the Supreme Court on the basis of the dissent, and the Supreme Court sides with the dissent, but the dissent and the majority both agreed that the Rule 60 motion should have been granted. It was just about other relief. And the Supreme Court in George specifically addresses Rule 60 and talks about it using some of the familiar language that we see in the Rule 60 jurisprudence about it being grand reservoirs of equity and the like. And I think the common link, if we have to make a distinction between why is Rule 60, a rule of civil procedure, being discussed in a post-Lux world, I think the answer to that is because nobody challenged it. And again, that's the commonality with our case as well. No one at any other previous time has said that the rules shouldn't apply, that Rule 60 shouldn't apply. Nobody did in George, nobody did in ACA. They both involved arguably Rule 60B4 and Rule 60B6, which appear to be the bases that were analyzed here. The previous opinion specifically talks about jurisdiction under 60B4, which is voidness and only applies in the jurisdictional context. So we think under those precedents that the court got it right the first time, and that it should continue to look to those precedents in sustaining the original decision. Are
there any time limits on, or I guess what are the time limits on when you can file Rule 60?
So there are time limits on certain subdivision, certain motions under Rule 60, depending on the subdivision. On a Rule 60B4 challenge, there is no time limit, and our case law is clear to that, and it makes sense if you think about it insofar as if a court, Rule 60B4 is about an absence of jurisdiction. If a court is proceeding without jurisdiction, whatever it does is a nullity, and there can be no time limit on challenging an action that was essentially a legal nullity. And I think that's important to note, too, in our case, because, I think I've read suggestions in our friends for the appellee's brief that they, whether Rule 60 is the right mechanism, whether some other mechanism might exist for challenging jurisdiction. And I think that is a little bit of a moot point insofar as if there's an absence of jurisdiction, it really shouldn't matter what you're calling the mechanism that you use to challenge an absence of jurisdiction, the court itself has a duty to inquire into its own jurisdiction. So if this is truly a jurisdictional issue, as the original opinion suggests, it doesn't matter if you call it a Rule 60 motion or something else. Those issues, again, we think that George is a controlling precedent from the state Supreme Court that supports this decision. ACCA is an unpublished opinion, as I recall, but it can be looked to as guidance. And in any event, it stands for essentially the same proposition as George, which may explain why it's unpublished, because it's not really treading new ground there. The third issue to be addressed is, as I understand it, in the court's original opinion, there is some discussion about the failure to include the statutory notice of neutrality that a substitute trustee is supposed to provide when conducting a power of sale foreclosure. And there is argument to the effect that that statute, that particular statute, which was 45-21.16, was not effective at the time that this particular foreclosure proceeding was commenced. And, candidly, I think the chronology is correct there, that particular statute had not yet gone into effect at the time. It came into effect at some point during the life of this case, but when it was originally instituted, I'm not sure that it was effective. I think, again, that is a bit of a red herring too, however, because the other statute that the court discusses in its initial opinion, 45-10, sets forth pretty similar precepts and was applicable. So whereas 45-21.16 says you must provide the statutory notice, 45-.10 says a substitute trustee cannot act as an advocate. So that it's a neutral party, but they can't advocate for the lender or for the borrower. What seems to be unchallenged on the record before this court is that the substitute trustee did act as counsel for both the lender and as substitute trustee. And that's not allowed under 45-1.10, which was in effect at the time, irrespective of whether there was this additional statutory notice requirement. The court's original decision for suggesting this was a jurisdictional failure relied on In re TRP, a case that originated in the, I believe, the termination of parental rights context, but it has applicability beyond that, and I think it's been cited beyond that, including in the court's original opinion, that says if there is a statutory scheme that's prescribing jurisdiction, and it has a procedure set out for it, for how that jurisdiction should be exercised, if the procedure is not followed, then the court lacked jurisdiction. That's, again, what happened here. There is a statutory scheme that says the substitute trustee must remain neutral, can't be an advocate for a lender or for a borrower, and what the record discloses and appears to be undisputed is that the substitute trustee acted as substitute trustee and as counsel for the lender. That procedure wasn't followed. If that procedure wasn't followed under the In re TRP case that the court originally relied on in its first opinion, that means there was no subject matter jurisdiction. If there's no subject matter jurisdiction, one of the recognized vehicles for challenging an absence of subject matter jurisdiction is Rule 60b-4. But again, whether Rule 60b-4 applies or doesn't apply, if there is an absence of jurisdiction, then nothing that proceeds is of any validity. It's an absolute nullity, and you can challenge it at any time, by any means. The case law says you can raise it for the first time on appeal to the Supreme Court. So that's one of those things that cannot be waived. It can't be conferred by stipulation or a failure to timely object. If there's no jurisdiction, there's no jurisdiction. It doesn't matter what you call your paper challenging that, whether you call it a Rule 60 motion or you bring a separate lawsuit or otherwise. If there's no jurisdiction, then it's proper to set that aside. And so that's what we believe that should happen here. One, I guess, unless there's questions, one final thing that I would note is when the court issued its first opinion it was a published decision. And now that the court's granted rehearing, this is candidly a very procedurally unusual case, I think. I think it's unlikely to have, sort of without progeny and unlikely to have any sort of precedents or like it or in the future. And so one option, I think, for this court would be to, in the same way that our Supreme Court sometimes takes cases on discretionary review and decides that discretionary review is improvidently allowed, in the Mole case, the Supreme Court took it really one step farther and said, you know, on second thought, we don't think we should have granted discretionary review here, but we would like to depublish the Court of Appeals opinion so that it stands without precedential value. I think that might be a guide for this court here. I think the court has granted rehearing. I think it would be in the court's discretion to decide that the rehearing was improvidently allowed, but that nonetheless, because of the unique procedural circumstances in this case, that it should stand without precedential value. And I think that's one option that the court might consider. But barring that, we think that the court should reaffirm its initial holding. If there's no further questions from the panel, then I will save the remainder of my time for rebuttal.
Good enough.
Thank you very much, counsel. All right, and at this point, we will go ahead and hear from the appellee.
Thank you, Your Honors. Again, my name is Hutch Hutchins from the Cumberland County Bar. I'm here for the petitioner appellant. And to be more exact on that, I am here on behalf of Chris Gross, Kelly Gross, Angela Pipes, and Donna Gross, who are the heirs of the lenders in this case. And that's important, and I'll get to that in a minute as why. I'm with Claire Dickerhoff, my co-counsel. I guess I'll start by going backwards from Mr. Archer's points and then get to my salient points. First of all, with all due respect, as to the discussion on 45-10 and 45-2116C7B, he has those flipped. 45-10 was the statute that was enacted after this foreclosure was filed. 45-10 codified some ethics opinions that were long coming, in my opinion, as to if a lawyer can serve as a trustee and represent a note holder in a contested foreclosure. And that's the language of 45-10 as I've laid out in my brief. When this foreclosure was filed, Mr. Matthews was serving as the trustee. I don't see anything, and have not seen anything in the record to suggest that Mr. Simmons nor his then counsel, Ms. Hyatt, contested the foreclosure, either prior to the clerk's hearing or at the clerk's hearing. What is, unfortunately, not in dispute is when Mr. Matthews, the trustee, filed his notice of hearing, which in these proceedings is the first pleading. He did not include the language in 45-2116C7B that the trustee must remain neutral. That statute came into, I think, in 2008, 2009, so certainly he should have done that. But I do not believe, as Mr. Archer states, that that is fatal to the foreclosure. I don't believe that a failure of a pleading to contain a statement that the statute, not suggests, but the statute requires, deprives a respondent of subject matter jurisdiction. This case, the George case that Mr. Archer discusses, does get to that point via Rule 60, and I'll get to that in a minute, but it says that the respondents were not served at all with the notice of hearing, depriving them of their due process, and that's completely correct. I believe that is a deprivation of due process. Here, the notice of hearing was served on Mr. Simmons and his parents. Mr. Simmons then hired a lawyer who served the lenders with RFIs under Chapter 45, that's their version of discovery, was given the information, reviewed the notice of hearing, did not notice that the neutrality statement was missing, came to the clerk's hearing, did not argue that fact. The clerk didn't pick up on that fact or make a ruling on it, and then that was not appealed. That order then becomes a matter of law. I believe that the proper vehicle for attacking the absence of the neutrality statement, to the extent that it's so detrimental to these proceedings, would have been at that hearing or on appeal. Going backwards from that, as to your question, Judge Griffin, as to the timeliness of a Rule 60, if it is allowed, the statute, as you know, requires a Rule 60 motion to be brought within 1 year. And then the catch-all provision of that is within a reasonable time. So let's look at the time of this case and what's happened in this case. A loan was given to Mr. Simmons, a personal loan by not a bank, but a personal lender in 2014 for $287,000 and change. That loan was supplemented by a second loan a year later because Mr. Simmons couldn't make payments. He was having financial trouble, and this private lender, out of the goodness of his heart and maybe bad business decisions, loaned him another $2,000. Each of those loans was secured by a deed of trust. No payments were made on either of those loans. The foreclosure was brought in 2016. The order by the clerk was entered in 2016. The Rule 60 or an appeal was not taken within 1 year. It was not taken within 4 years. So the clerk's order was entered. Mr. Simmons files a series of bankruptcies, hires a separate lawyer who files a lawsuit to collaterally attack the foreclosure, which he's allowed to do, by the way, under 45-21.34, and I'll get to that statute in a minute as well. That lawsuit was dismissed. Then the property goes to sale. No Rule 60 or no attack on the foreclosure is made under either the proper statute or Rule 60. The sale confirms before an attack is made on the foreclosure. He waits over a year to file this, in my opinion, improper Rule 60 motion a month after the last lender passes away. Waits until the lenders have passed away. Before that happens, under 45-21.29A, which I talk about a lot in my brief, the legislature has determined that at the 10th day after a sale has occurred and there's been no upset bids and no collateral attacks, the rights to the parties to that sale are fixed as a matter of law. They cannot be disturbed. And if you think about it, that makes sense. If that foreclosure auction had gone to a third party out in the public, what is Mr. Simmons going to do? File Rule 60 and yank the property back from a third party? Well, the credit bidder, in this case, who did it, went in the highest bid, stands in those same shoes. So it is not proper to wait, in my opinion, to file any kind of action after that time period has passed. And in fact, 45-21.34 explicitly states that. It says that if there's going to be an attack on the foreclosure order or sale, to set it aside for insufficiency of process, for insufficiency of sale price, or for any legal or equitable ground. So a catch-all provision for this fellow. It must be filed before the rights of the parties are fixed under 45-21.29A. That, in a roundabout way, is kind of the Rule 60 version in Chapter 45. The catch-all provision allows you to set aside and collaterally attack these proceedings if you believe you have a legal or equitable ground. And you must do it before the rights of the parties are fixed. Speaking of the George case, obviously I wasn't a lawyer in that case, and we do some HOA foreclosures in our office, but it is a different vehicle. They are different creditors. They don't have the governing rules from the federal government, the CFPB, and all these bodies looking over their foreclosures. They don't have years of loan history payments that have to produce and discuss, but it is a different foreclosure. And in fact, I hear grumblings in the legislature now that they're going to move HOA foreclosures to a judicial foreclosure process and pull them out of this non-judicial process, which may be good or bad depending on how you look at it. But in any event, it is a different foreclosure. And then when you read the Lutz case that was written by Justice Newby, that we hoped had finally kind of driven a nail into this discussion, he says that the Lutz standard is applied to Chapter 45 foreclosures of mortgages and deeds of trust. And I can pull the case and read specifically, but that's exactly what it says. It did not discuss anything else. Now, it's true that Chapter 47F for HOA foreclosures does itself engraft those procedures unless there's other ones in place, but it does not do so fully. And the Lutz case did not address HOA foreclosures any more than the George case discussed deed of trust foreclosures. As to the applicability of George, Mr. Archer was kind enough and correct enough to mention that in that both the appeal to this court and to the Supreme Court, there was no discussion by any lawyer or party about the applicability of that standard to Chapter 45 foreclosures. I wish that someone had been there to do that, and maybe the ruling would have been the same, but that's not the case, and we're left with that. But I do believe there's a distinction between the George case and the Lutz case. Speaking of the Lutz case, it really has been a battle of 1976 to 2017, so 40 years, to try to get that standard nailed down. Beginning in 1976 with the case of First v. Lofton, this court finally said, or initially said, that it's clear the rules of civil procedure cannot apply to Chapter 45 foreclosures. Over the next 40 years, there were cases of bad law or maybe folks who don't practice in this niche taking up a civil procedure rule to this court. There was a case involving a 41 dismissal rule, a case involving a Rule 60 that was applied to Chapter 45 and then had to be later attacked by separate cases to reset the fact that civil procedure rules cannot apply to Chapter 45 foreclosures. And it's not just any kind of industry or bar protecting its nest egg. If you think about it, it wouldn't make much sense, in my opinion, for that to happen. In a non-judicial power of sale foreclosure, there cannot be a motions practice. There is no discovery or deposition practice. There is no practice regarding summary judgment motions. There cannot be a demand for a trial by jury. Chapter 45 has, as the cases that discuss this say, developed its own procedural grounds. It has its own procedures for hearings, its own procedures for service, its own procedures for discovery. In 45-101 through 109, there's RFI cases. You have to follow the federal rules from the CFPB and Fannie and Freddie and these government entities to conduct your foreclosures properly. It has its own appellate process. So the legislature has considered all of this and made that its own separate kind of microcosm within our statutes. And that is certainly, I believe, that's where it should stay. Going to Mr. Archer's first point, and it's a good point that is made, we were not present as a law firm, and unfortunately my client, nor was present, after the record on appeal was settled to file a brief. It was thought he was represented and was not represented at these proceedings, and so a brief was not made after the record on appeal was settled, by the way, by the pro se appellant and not with any contribution from the other side. But I believe, and I don't do as much appellate work as Mr. Archer does, but that is kind of the reason and purpose of the petition for a rehearing. At least that's what we used it for. We saw misapprehension of law by this distinguished panel because there was no one from this side of things, for the lender and from the creditor's bar, to kind of lay out what the procedures should be. And so we filed the petition, and it was granted. So I'm hopeful, and I believe that is kind of gives us the permissive ability to be here and make these arguments, that there was a misapprehension of law as to the applicability of Rule 60 and the trustee statutes. If I may, then, I'll move to some more salient arguments. I won't rehash my brief. I know that you guys have read it. But again, I mentioned at the outset who my clients are. I represent the heirs of the lender. But pursuant to the statute I mentioned earlier, 45-21.29A, when the sale confirmed, Mr. and Mrs. Gross, Donald Gross and his wife, Betty, were vested and entitled to this property, these tracts of land. The note is then satisfied. The lien is then extinguished. There is no more loan. There's no more privity of contract between the lender and the borrower. And the Grosses became vested in fee simple of this property. Then, unfortunately, within just a year of that happening, they each passed away, respectively, in June and September of 2020. When that happened, as we know, that property passes to their heirs, the two that are behind me today and two back in Yadkin County. I don't know how a trial court, if it's remanded back for them to do so under Rule 60 or any other procedure, or this court could breathe the loan back into existence. It's one thing when a lien is extinguished by accident, the other faculties of a loan remain in place, the parties remain in place, there is a vehicle to breathe life back into a lien. But in this case, the note is gone. After it was satisfied and it was adjudicated, I don't know that Mr. Gross or his sisters know where the note is. So where do we go from there? Mr. Simmons, having never paid a single payment on the note, would then receive the properties free and clear. I don't believe that would be what the law would require in this case. So I'm concerned about where to go, and I don't really have an answer for it, I'm sorry. about if the court decides to rule for Mr. Archer, how we go back and begin again when there are no lenders. So certainly Mr. Gross and his siblings don't wish to become lenders to Mr. Simmons or anybody else for that matter, and certainly not under the terms that were in this loan. So that is kind of one of our primary concerns. Speaking as to the applicability of, Rule 60, and again, I think I've gotten there pretty much already.
So is it your position that Rule 60 wouldn't apply at all, or they were just faulty in how they went about it?
I'm sorry, say again?
Yeah, so the Rule 60 motion, is it your position that they weren't, that relief was not available at all?
That's correct.
Okay, not just that it was tardy in being executed?
Yeah, 100%, that's exactly right. And it's something Mr. Archer said earlier, and I failed to mention, when this matter got in front of the trial court on Mr. Simmons' Rule 60 motion, it was not then a de novo review. The de novo review of a clerk's order happens if an appeal is taken within 10 days to Superior Court, not 4 years after on a Rule 60 or anything else. And again, had Mr. Simmons brought a separate lawsuit under 452134 to the Superior Court, I think all these issues could have been hashed out in the proper way. And listen, I understand Mr. Simmons is acting pro se. Mr. Johnson, Mr. Matthews, who may not practice in this field very often, did not address the fact that the Rule 60 wasn't proper before the court. But the court ultimately got to the right decision that the parties, they didn't say this in their order, but I believe they got to the point where the foreclosure is completed. It cannot now have been upset. I do believe, Judge Griffin, that it is inapplicable. Again, I don't know if we're going to allow a reversal of Lux after all the years of trying to get it right and allow Rule 60 to be applied to Chapter 45 foreclosures in front of the clerk on appeal before the Superior Court or 4 years later on its own motion, what other rules of civil procedure are going to be allowed? I certainly have seen no case law or heard no argument that we should piecemeal the rules of civil procedure and just allow Rule 60 to be applied.
So your distinction between Lux and George is that it was a HOA foreclosure?
Right now, that would be my distinction, yes, sir. If we look at Justice Newby's language in Lux, it does specifically apply his standard, which says that it's clear and that civil procedure rules will not be applied to Chapter 45 foreclosures, and any law that says otherwise before here is overturned. I mean, again, I wanted to be settled. Chapter 47 was not considered by Justice Newby, but again, I can argue that 47F does try to engraft some of those procedures, so the procedures are similar, and if I was in the George case, I would have made the same argument I'm making here today. But the distinction is that it's an HOA foreclosure, it's under Chapter 47F, and if I'm relying on Lux, which I am, Lux only applied to Chapter 45 deed of trust foreclosures.
Well, wasn't the crux of the case in In re George that the parties were not actually served with the notice of the foreclosure?
Right, and I meant to allude that to earlier, and if I wasn't clear, I apologize. There is a larger violation in George, in my opinion. The respondents in that case weren't properly served, at least that was the allegation. They weren't properly served and were then deprived of their due process. I guess if you're asking what should happen then if that happens in a Chapter 45 foreclosure, well, it should be addressed in front of the clerk on appeal, or the best vehicle for that would be to file a separate lawsuit under 452134 and join the foreclosure, get in front of a Superior Court judge, go through the discovery and the evidentiary discussions you need to have to get to those points. But, again, I don't know if I want to relitigate George before this tribunal, but that's not what happened here. The absence of the neutrality statement, while certainly enlisted in the statute, did not deprive Mr. Simmons of his due process, did not deprive Mr. Simmons of his rights. I don't know of any law that makes an absence of a pleading or an absence of a provision in a pleading that's been fully adjudicated and where the rights of the parties become fixed, ripe for a reopening under Rule 60. I'm trying to think of a way to compare it to something if you're just in your regular pleadings practice, but certainly if it's not picked up upon during the adjudication of a lawsuit, I don't know how it then can be reopened if the parties there too didn't pick up on it to begin with. I believe Mr. Matthews should have included that. We certainly include that in all of our notices of hearing, but the absence of that did not deprive anybody of their due process. And since 45-10 was not yet codified to require the trustee to be separate in its representation of a lender and the trustee, he didn't even violate that statute. What he violated, or what was missing, was a simple statement in the notice of hearing that says this trustee will remain neutral during these processes. To carry that thought further, as I mentioned earlier, there's nothing in the record to indicate that at the clerk's hearing, or even, well, it didn't appeal it, so at the clerk's hearing, that Mr. Simmons or his lawyer contested the foreclosure. There was no evidence presented to the clerk contesting the 6 elements that a clerk's required to consider, no testimony or evidence presented about the valid debt or an absence of default. That was all done 4 years later for the first time on this Rule 60 motion before a Superior Court judge. And again, it would be my opinion that if you don't raise that before the proper trier of fact and the court of competent jurisdiction and original jurisdiction in these matters, then you may have lost a bite of that apple. And again, certainly under 452129A, it clearly says the rights of the parties are fixed at the confirmation of the sale. And then 452134 says any attack or to set aside or enjoin this foreclosure must be done before those rights are fixed. And I don't believe I have much else unless there's questions. Thank you.
Thank you, counsel. All right. So we'll hear a rebuttal from the appellant.
Thank you, Your Honors. I'm Henry Hilston of Blanco Tackleberry for the appellant, and I'll present the rebuttal arguments here. And I'll just start to clarifying on 45-21.16 versus 45-10. I think our point still stands that the notice of neutrality has to be sent for there to be a sufficient notice under that statute. That notice was not sent here, and there has to be a remedy for that failure to comply with the statutory scheme. And just to bring in an analogy in the termination of and I don't have a case like for this, unfortunately, but a termination of parental rights setting, this court has previously held that a failure to verify pleadings leading up, I believe, the complaint for a termination of parental rights is a procedural issue that deprives the court of jurisdiction. So that would be an analogy where, just as here, there's a statute that says you have to do something procedurally before you can set out this or pursue the relief requested. And if you fail to comply with that procedural requirement, then the court is deprived of jurisdiction. And so that's a similar situation here where that's exactly what happened under 45-21.16C7. That notice was not sent. There has to be a remedy for that. And we would ask that the court analogize those two settings and consider as well as another point that Rule 60 is called by this court and the Supreme Court and others a reservoir of equity. And regardless of what you call this motion that was brought, it is a motion considering subject matter jurisdiction in at least one regard. And we're saying, and we read the previous opinion in this case as saying, or at least leading to the inference, that subject matter jurisdiction did not exist when there was no proper notice sent or there wasn't a neutral trustee.
How do you respond to Mr. Hutchins' contention that that issue wasn't even raised in front of the trial court? That wasn't the basis for the Rule 60 motion.
Yes, Your Honor. I guess, right. If there's no subject matter jurisdiction, Your Honor, that's something that can be raised regardless of whether it was preserved at the lower courts. So that's something, whether it was introduced at the lower courts, it can be raised at the Supreme Courts. Our courts have held that in many different cases. And accordingly, we would contend that whether or not it was raised at the lower courts or before the clerk, it was properly raised later on appeal and can be raised at any point in time. So that's how we respond to that argument.
So saying that the Rule 60 motion applies here, how do you respond to the reasonable time argument?
Just in a similar way, Your Honor, for one thing, Rule 60, I think, there was ongoing litigation. I think the facts of this case, if you look at the facts, there were ongoing litigation that maybe Mr. Simmons or others thought would resolve all these things, had placed a stay on the various state court proceedings. So that was one factor that would have makes his delay reasonable in filing his Rule 60 motion at that point. But in addition, if this is a subject matter jurisdiction issue, there is no time limit on when he could raise this. It was reasonable to raise it at any point in time, whether 4 years after the initial notice of hearing on the foreclosure or on appeal in 2022. So there would be no limitation on that, raising that argument based on that. If you'll give me just a second, Your Honors, apologies, I'm just going over my notes. And just to go back to the argument regarding the abandonment and waiver of issues below, there's case law in North Carolina that suggests that constitutional arguments regarding the deprivations of rights are waived as well, even if they're not raised in the lower courts or in the appellate brief. So it's not just that we're talking about, someone losing the right to raise these arguments about a debt on appeal, but there are much larger things that are waived and abandoned as well. But I think those are all our arguments on appeal or on rebuttal if there's any questions.
Well, if the rights of the parties have been fixed and 10 days after the actual foreclosure, and this motion wasn't filed until 4 years later, what is your contention as to what would happen now? Your client would owe the $230-some thousand to the people who don't want to be lenders?
That's correct. And that brings up a good point, Your Honor, that the debt's not going to go away. He would still owe it to them. But the risk to the lenders is actually quite low here where, if the court decides to reverse and remand the lower courts, then they're going to go back and properly file this foreclosure, improve their debt. But that is the point of this, is to hold them to the standards that the statute set out and make sure that they're following those procedures and doing everything correctly. So I think the risk is, what we would be doing is sending them back to this debt that no one doubts exists and that he owes. And we would probably just have a foreclosure again. But thank you, Your Honors.
Thank you.
Thank you.
Thank you, counsel, very much for your arguments. This matter is now before the panel, and we are adjourned.
All rise. This session of the North Carolina Court of Appeals is now adjourned.